Every time you step outside your front door, your face is being captured, cataloged, and instantly cross-referenced against billions of digital records without your explicit knowledge or consent. A massive, unregulated legal loophole currently allows government agencies and private tech corporations to deploy public facial recognition tracking with virtually zero federal oversight. This invisible, omnipresent dragnet is actively eroding the fundamental right to anonymity, transforming your routine daily errands into permanent, searchable entries in heavily monetized, unregulated databases. The core of this massive vulnerability lies in an antiquated legal framework that never anticipated the rise of artificial intelligence capable of instantly identifying specific individuals within a dense crowd. Because there is currently no comprehensive federal law governing biometric data collection in the United States, a chaotic patchwork of conflicting state regulations has emerged. This massive regulatory void creates a legal loophole where the simple act of walking down a public street is legally interpreted by aggressive data brokers as implied consent for permanent biometric tracking. To truly understand the severity of this threat, one must examine the silent mechanics of data scraping, an invasive process where automated software extracts massive amounts of personal information from public websites. Private surveillance companies like Clearview AI have built multi-billion-dollar business models entirely on this practice, indiscriminately scraping billions of publicly available photos from social media platforms and employment directories. They feed these stolen images into proprietary algorithms to create highly accurate facial recognition profiles, effectively turning the open internet into a massive, non-consensual police lineup. The immediate impact on your personal digital autonomy is both severe and irreversible. When a private corporate entity holds an unregulated database containing billions of faces, anyone from local law enforcement officers to corporate security teams can purchase access to identify you in mere seconds. Your physical location, your personal associations, and your daily habits are no longer private, stripped away by a ruthless system that assumes your mere public presence legally forfeits your fundamental right to digital privacy. This pervasive, unblinking monitoring fundamentally challenges the core protections of the Fourth Amendment, which explicitly guarantees the right of the people to be secure against unreasonable searches and seizures. Historically, the legal doctrine of public space dictated that individuals have no reasonable expectation of privacy when they are physically out in the open. However, traditional surveillance required immense human resources and physical effort to track a single individual, creating a natural friction that protected the general public from continuous mass monitoring. AI-powered biometric tracking completely eliminates that historical friction, creating a frictionless surveillance state. Courts across the country are now grappling with the terrifying legal distinction between a police officer observing a suspect on a street corner and a digital network continuously logging the precise movements of millions of citizens simultaneously. In the landmark case Carpenter v. United States, the Supreme Court recognized that sweeping digital records provide an intimate, unconstitutional window into a person's life, warranting strict constitutional protection against warrantless access. Despite the powerful logic established in the Carpenter ruling, its vital constitutional protections have not yet been definitively extended to public facial recognition tracking. Law enforcement agencies routinely exploit this dangerous legal ambiguity, arguing that matching a face captured on a public surveillance camera to a scraped online photograph does not legally constitute a search under the Fourth Amendment. This aggressive legal interpretation allows government agencies to entirely bypass the traditional requirement of obtaining a warrant based on probable cause, relying instead on unregulated corporate databases. The societal consequences of this unchecked warrantless surveillance extend far beyond theoretical academic privacy concerns. The terrifying knowledge that one is being constantly monitored and cataloged creates a profound chilling effect on the freedom of movement and the freedom of peaceful association. Citizens may increasingly hesitate to attend political protests, visit specific medical clinics, or associate with certain marginalized groups, knowing their physical presence is being permanently recorded and easily searchable by authorities or private actors with a hidden agenda. The sheer operational scale of these corporate surveillance databases is staggering and unprecedented in human history. Clearview AI alone claims to have amassed a staggering database of over 30 billion individual images. This unparalleled, aggressive aggregation of your personal data is achieved entirely in the shadows, utilizing relentless algorithms that never sleep and never stop scraping the internet for new faces. The software maps the unique geometry of your face, creating a permanent biometric template that is as distinct as a fingerprint, but captured from a distance without any physical contact. When aggressively challenged in federal court, these data brokers often deploy a highly controversial legal defense, audaciously claiming their massive scraping operations are fully protected under the First Amendment. They argue that collecting publicly available photographs and organizing them into a searchable database is simply a modern form of protected speech and journalistic information gathering. This aggressive, cynical legal strategy attempts to shield the commercial exploitation of your deeply personal biometric identity behind the very constitutional amendments designed to protect individual liberties. This audacious First Amendment defense creates a highly dangerous synergy between private tech companies and government law enforcement agencies. Because police departments face much stricter constitutional limits on building their own mass surveillance databases, they simply purchase subscription access to these corporate systems. This deeply unethical practice effectively outsources mass surveillance to the private sector, allowing the government to easily circumvent the Fourth Amendment by buying vast amounts of data they legally could not collect themselves without a judge's explicit approval. The real-world application of this outsourced, unregulated surveillance has already resulted in devastating personal consequences, particularly regarding the technology's well-documented inherent flaws. Facial recognition algorithms have consistently demonstrated significantly higher error rates when attempting to identify people of color, women, and older individuals. These technical inaccuracies have directly led to multiple highly publicized cases of false arrests, where innocent citizens were jailed and traumatized solely based on a flawed algorithmic match from a low-quality public surveillance camera, while the federal legal landscape remains dangerously unregulated and chaotic. The state of Illinois offers a powerful, proven countermeasure through the Biometric Information Privacy Act, commonly known in legal circles as Illinois BIPA, enacted in 2008. This pioneering piece of legislation correctly recognized the permanent, unchangeable nature of biometric identifiers and established extremely stringent legal requirements for their commercial collection. It serves as a vital, actionable blueprint for how state law can successfully restrain unregulated biometric tracking and protect citizens. Illinois BAPBA mandates a strict legal principle called explicit consent, legally requiring private companies to directly inform individuals in writing and obtain their written release before collecting or storing their biometric data. Furthermore, the law grants citizens a powerful private right of action, allowing them to sue violating companies directly in civil court. This specific legal mechanism has proven incredibly effective, forcing massive global tech corporations to pay hundreds of millions of dollars in settlements for unauthorized facial scanning and data harvesting. However, the robust legal protections of Illinois BIPA absolutely do not cross state lines, leaving millions vulnerable. This creates a dangerous, unacceptable geographic lottery where the fundamental legal rights over your own face depend entirely on your current zip code. The vast majority of Americans currently reside in states with absolutely zero biometric privacy laws, leaving them completely exposed to the unregulated scraping, tracking, and monetization operations of the booming commercial surveillance industry. Recognizing the existential financial threat that strict consent laws pose to their highly lucrative business models, tech industry lobbyists are aggressively pushing back nationwide. They actively campaign against any new state-level biometric bills and continuously attempt to quietly amend existing laws to permanently remove the crucial private right of action. If citizens cannot sue for direct violations, the financial penalties for illegal tracking become mere operating costs for billion-dollar corporations, rendering the privacy laws effectively toothless and entirely symbolic. The critical battle over biometric privacy is now inevitably shifting to the federal level, though legislative progress remains agonizingly slow and heavily compromised. Various Senate bills have been repeatedly proposed to establish a unified national standard for data privacy and algorithmic accountability, but they frequently stall in committee debates over the issue of federal preemption. Tech companies lobby heavily for weak federal laws that would permanently override stronger state protections, aiming to establish a minimal, easily bypassed compliance standard nationwide. As this dangerous legislative gridlock persists in Washington, the normalization of invasive biometric surveillance continues to accelerate rapidly in daily life. Facial recognition technology is increasingly integrated into local retail stores, major sports stadiums, and residential security systems, almost always justified under the deceptive guise of consumer convenience or enhanced public safety. This rapid, unquestioned deployment conditions the general public to accept constant biometric scanning as an inevitable aspect of modern life, slowly eroding the fundamental societal expectation of public anonymity. Privacy advocates and civil liberties organizations consistently issue stark, urgent warnings about the inevitable mission creep of these pervasive tracking systems. What initially begins as a specialized tool for identifying violent fugitives inevitably expands to track petty offenses, monitor peaceful political activists, and enforce minor civil infractions. The historical precedent of surveillance technology clearly demonstrates that once a powerful tracking capability is deployed, its application broadens relentlessly until it becomes a permanent instrument of generalized social control. The profound psychological toll of living constantly under a digital microscope cannot be overstated or ignored. When the simple everyday act of existing in a public space becomes a monetized data point to be harvested, analyzed, and sold to the highest bidder, your personal autonomy is severely compromised. The individual citizen is effectively reduced to a trackable corporate asset, their movements and personal associations scrutinized by opaque proprietary algorithms that offer absolutely no transparency and no legal mechanism for appeal. Reclaiming your digital autonomy requires immediate, decisive, and informed action to actively disrupt the data supply chains that feed these invasive algorithms. The absolute first defense strategy is to aggressively utilize all available data broker opt-out mechanisms. While comprehensive federal law is currently lacking, you can manually demand the complete removal of your personal information and images from major data aggregators, effectively starving the facial recognition engines of the raw digital fuel they desperately need to operate. You must also conduct a rigorous, ongoing audit of your digital footprint to minimize your daily exposure to automated corporate scraping. This critical process involves locking down all social media profiles to the strictest privacy settings, permanently removing identifying photographs from public professional directories, and utilizing stylized avatar images instead of real faces on public forums. By drastically reducing the volume of publicly accessible images, you directly degrade the accuracy and reliability of the biometric profiles being built against you. Beyond essential individual data hygiene, the single most effective defense against public facial recognition is actively advocating for strict local municipal bans. Over 24 cities across the country have successfully organized and passed binding ordinances prohibiting their local government and police departments from acquiring or using facial recognition software. These crucial local victories create vital geographic sanctuaries of privacy and build immense political momentum for broader, more comprehensive state and federal legislative restrictions. Implementing the principle of privacy by design in your daily life is another crucial, highly effective layer of personal defense. This proactive concept involves making deliberate, informed choices about the technology you use and the physical environments you choose to enter. Refuse to use biometric payment systems at retail checkouts. Legally opt out of facial scanning at airport security checkpoints where manual alternatives exist. And financially support businesses that explicitly pledge not to use biometric surveillance on their customers. The glaring legal loophole allowing public facial recognition tracking represents one of the most severe, immediate threats to personal liberty in the modern digital age. By ruthlessly exploiting the widening gap between outdated constitutional interpretations and rapidly advancing artificial intelligence, private corporations and government agencies are actively constructing an inescapable, nationwide surveillance infrastructure. Investigating the legality of these systems reveals a desperate, urgent need for comprehensive legal reform and immediate, uncompromising defensive action from every citizen. Your face is your most fundamental, unchangeable identifier, and its absolute legal protection is paramount to your continued freedom. Do not wait for sluggish federal legislation to finally catch up with the aggressive technology that is currently cataloging every aspect of your life. By fully understanding the silent mechanics of biometric exploitation, relentlessly utilizing opt-out procedures, and demanding strict local accountability, you can actively block these legal vulnerabilities and secure your right to remain anonymous in a heavily surveilled world. Follow for more legal clarity.